The EJB was founded in 1999 by a group of business executives and entrepreneurs, and now has a network of about 450 prominent businessmen representing over 18 different sectors and employing over 270,000 employees. The construction committee is one of the largest committees in the association and has around 96 members. The EJB has three pillars. The first pillar is members' business support. The second pillar is enhancing business environment. And the third pillar is community development. The EJB has a number of initiatives. Some of them that active initiatives at the moment are اشتغل. اشتغل is a vocational training for blue collar and white collar employees or youth to prepare them for the job market, and this is under the auspices of the President of Egypt. The second initiative is the Anti-Corruption Initiative in association with the United Nations Global Compact and Siemens, focusing on anti-corruption in the private sector. The third initiative is the Key Program. The Key Program is a development program for graduating students from Egyptian universities to help them in the job market after graduating. And the fourth program is مشروعك حقيقة. مشروعك حقيقة, the EJB provides angel loans to up to 100,000 Egyptian pounds and technical support for SMEs. As part of the second pillar of the EJB, which is enhancing the business environment, the EJB works with the government and with the public and private sector on promoting the business environment in Egypt. Part of this promotion is the dispute resolution. We have seen over the last months when the government was discussing the new investment law, how the business community complained from the dispute resolution mechanism in Egypt, and litigation takes a lot of time. Arbitration is becoming very expensive, and mediation has proved successful in many countries. Disputes can now be resolved in a matter of days instead of months and years. Our speakers today are Ms. Aisha Nadar. She combines many different skills. She's an engineer. She has a master's degree in international commercial dispute resolution. She worked as a consultant in construction mediation and did several projects with the USAID, with the Ministry of Defense in Egypt, with the Ministry of Defense in the US. I think she's the most qualified person to talk to us today about mediation in construction disputes. Our speaker also is Dr. Ahmed Wali. He's the managing partner of Wali Arbitration and Contract Administration firm. He has more than 20 years experience in managing construction contracts for projects in different countries. He participated in several institution ad hoc arbitration cases. He acted as mediator and as party's representative in mediation. He's an assistant professor in the Department of Construction and Architecture Engineering at the AUC. And he has several refereed journal and conference papers published in Egypt and in many other countries. I will now give the floor to my colleague Fatma. Just introduce you. And Ms. Fatma Ibrahim of the IFC. She's the operations officer at the World Bank Group. She leads projects for the promotion of commercial mediation, insolvency reform, investment promotion, competition and industrial licensing. She's currently based in Egypt, and her portfolio covers projects in Afghanistan, Bangladesh, Egypt, Saudi Arabia, Lebanon and Morocco. I give the floor to Ms. Fatma.
Thank you very much. And I'd like also to thank the EJB, the Construction Committee, the Legal Committee for co-hosting this event. I'd like to thank the attendees. I understand this is a very compact period because it's before Ramadan, so I'm very happy that you made the time to attend and listen and understand more about mediation, and hopefully you will be more convinced by the end of the seminar. So briefly, how many of you have had court cases? Oh, you're very happy, no court cases? خالص? واحدة شغالة for how many years? 6 months, alhamdulillah, very good, 6 months is excellent. And yours? And how long did they stay? 3 years. Enforce? More time. Were you happy? No. So, did any of you try arbitration before? Okay, and on an average, how much time did it take? A year. Very good. Court of appeal. Okay. This is what we call in IFC, which is the International Finance Corporation, part of the World Bank Group, a market failure. So we study and we see a market failure. According to one of our flagship reports, the Doing Business, and the Doing Business in Egypt says it takes at least 100,000 days to resolve a case in court, which is of course not realistic. It takes much more. And enforcement takes even more, and some people don't even want to enforce their cases because the verdict, if it's for them, because they think the value of money has decreased to an extent that it has become ridiculous. For SMEs, this is lethal, and SMEs can be bankrupt, liquidated, if they cannot take their rights swiftly through the court proceedings. Arbitration definitely is a much better alternative, but still not affordable for many, and still also lengthy, especially when it comes to its enforcement. So we've defined this as a market failure, and we work with a number of institutions to promote the concept of mediation, which is an alternative to the court system, alternative to litigation. And actually some scholars would say that this is the principal mode, and litigation is an alternative, because people used to settle their cases amicably. I'm not going to talk more about mediation, and I leave this to our very learned speakers today. But this is why IFC is interested in promoting mediation, to help investors, companies settle their disputes more quickly, more efficiently, and keep on and produce and reinvest their money in the market. So the project started in 2009. We have as clients the Cairo Regional Center for International Commercial Arbitration. We have the General Authority for Investment and Free Zones. They have their own mediation center. And we also used to collaborate with the economic courts of the Ministry of Justice. So far, the project, and we speak later about this in greater detail, has resulted in a number of cases resolved through mediation with amounts released. And this is the main measure of our success, because we're actually an investment mostly organization, IFC, if you've been familiar with it. So we measure it in terms of money, whether there was good return or not on our investment in the project, and so far it has been very satisfactory. And again, I'll speak later about this. We've been training mediators. Jamal and Ahmed are actually one of our two mediators and trainers, and they have trained in Lebanon and Morocco, and hopefully train soon in Egypt. We help the centers we collaborate with to revise the mediation rules, and both of them have been issued. We also help them in reforming their case management system. We work with the Ministry of Justice in developing a comprehensive commercial mediation law that deals with judicial and private mediation. Due to the successive changes of regime, this law has not been receiving government priority, but hopefully soon when time is right. So with no further ado, I will end at this. And again, thank you very much for attending. And I'll leave it to Aisha, please.
Before we start, our executive director is asking everyone to fill the survey, the assessment of commercial dispute resolution approach, and hand it to the association before the second break. Thank you.
Great. Thank you so much to both Fatma and Gamal for such an eloquent introduction of the topic and of EJB and of Ahmed and myself. What Ahmed and I would like to do today is really kind of share our experiences in construction, disputes, and mediation, and how that fits, and how mediation can play a role, or if it can play a role within the cost-effective management of disputes. So what we'd like to do for today is briefly introduce the construction mediation initiative within IFC, and I will then participate in talking about, I will start off by introducing the spectrum of dispute resolution tools and techniques. And from there, we will talk about the features, the advantages, and the disadvantages. So what we heard from Fatma is mediation has become more widely used in Egypt over the past 5 years. And in fact, the Cairo Regional Center updated its mediation rules in 2013. And we can see that the IFC mediation project was fairly successful in meeting some of its objectives. And they launched a mediation construction initiative to investigate the possibilities of using mediation in the construction sector, and if so, can we do it in Egypt, and if so, how? To do this, the first idea was to kick off by establishing a mediation construction working group. And with the first activity of that group, or the first initiative of that group, was to undertake a survey of stakeholders to assess the current status of the industry in Egypt. And I'd like to introduce you to the members of the working group. And Ahmed and I are both members. We're led under the IFC umbrella, under Fatma's direction. But I'd like you to note not so much the individual names, but rather that it's a cross-functional group that is comprised of both lawyers and engineers and various participants, and it includes participation from the Cairo Regional Center. And that the reason behind that was to not get a skewed view. As we know as participants in the construction industry, it's a cross-functional industry that takes partnership of the players for success. So we wanted to ensure that we got a realistic cross-functional view without heavily weighing it towards the legal side or the consulting engineering side, but rather more of a balanced view. So the idea of a cross-functional team was to ensure that checks and balances from both parties. Now, what we did as the first initiative in meeting with the stakeholders, we met with developers, contractors. We met with many of you in the room to understand if we're looking at mediation in itself. Yes, it works, and it's continued to work in the U.S., but without understanding the contours of the Egyptian construction industry and the nature of disputes within Egypt, we didn't want to suggest mediation beforehand. So we wanted it to be, as often Fatma says, demand-driven. We wanted it to be focused and delivered with the reality on the ground. So that the meetings with the stakeholders was going to inform the working group of a go, no-go decision in regard to construction mediation in Egypt. And what we found in this, during this time, we found that there were barriers to mediation. It wasn't so much a refusal of mediation, but maybe a lack of awareness of what mediation is, what it isn't, and how it can play a role, if at all. But there was an openness to understand better. So what as a result, we undertook the mediation initiative to create an awareness, to provide the information, to meet with the various stakeholders and provide the information that they need to be able to use mediation as a tool. And I think we'll underline that and we'll see as the day progresses that it is a tool, and it's an additional tool in the toolbox. Fatma mentioned litigation and arbitration. Those are also effective tools, but when and how to use each of them and how to select them is what we're hoping to share with you today. And so why does this all matter? Because we talked about litigation and arbitration, and they are tools, but they're not the only tools. Sometimes they are the best tool to use, but they can be very expensive. When Fatma asked about experiences with litigation, it didn't make you happy. It may have resulted in a court decision in your favor. Enforcement took a while, and you may have ended up with some money. Maybe if you compare it to the amount spent in legal fees, it may not have been what you would hope for after a lot of frustration. So, can mediation present itself as a viable option, and when should we look at it, and how could we use it? The other aspect is, and we learned this from the stakeholder meetings, and Egypt is is a viable and vibrant participant in the global market, and the construction industry is no exception. So there's a symbiotic relationship. What happens is Egypt informs and also is informed by the global construction industry. And there are aspects of the global construction industry, for example, the US and Ireland, as just to name two, in where mediation plays an active role. And if you start looking at standard contracts that find their origin in that home or that jurisdiction, you will see mediation as sometimes a tool or a tool of choice. So if participation in the construction industry starts becoming a joint venture or a consortium with an American counterpart, they may be using the American Institute of Architects as a standard contract, maybe not the full standard, but at least as their basis of information for a negotiating starting point. So if you find yourself in that approach, you may not choose mediation for your domestic transactions, but it suits to be well informed of mediation if you find yourself in that sort of situation with an American counterpart that is leaning towards mediation. So at least you can have an informed discussion about when and how to use it. So with that background, we have structured today to first introduce the spectrum of the tools, the advantages and the disadvantages. Sorry, you're pointing, is there something? Oh, okay, you're reading with your finger. Thought, oi. Okay, so we're focused on introducing the spectrum of the tools. Then we want to talk a bit about the construction industry and the type of disputes, and then look at the advantages and disadvantages of these tools in relation to each other. So the idea isn't for us today is not to just simply say mediation is the only tool, but it is a tool, and how do we make an informed choice? Then we carry on. Ahmed is going to explain much more in depth about what mediation is and how the process works. So if we find that mediation can be a positive tool, then how does that work for us? And then we'll carry on after Ahmed's presentation to share the practical experiences in Egypt. And it'll be a session that I will moderate, and it'll be somewhat of a dialogue, a structured dialogue with Fatma and Ahmed to share more in depth the particular experiences, be it mediation in a commercial context or mediation in a construction context, and how it works and where it may not have worked. And then we've left an hour to questions and answers. And that session is intended for you to ask Ahmed and myself whatever it is that you find that we may have left out, that you would like to expand on. And we're here to have a discussion and a dialogue, and for you to help us to, if there's something that we may have missed or that needs to be expanded. So the only point that I'd like to add to this structure is while we're presenting, if something is unclear or you have a question that may provide a better context, please ask during the presentation, because there's nothing worse than misinforming for us than misinforming or something that isn't clear. If there's a question that we feel may be better answered at a later time or in the question and answer session, we'll with your permission, we'll ask to defer it till that point. But please raise your hand and feel free to interject or ask questions throughout the presentation and throughout the day, because at the end of the day, this is your day. This is your day to gain the information that you need to make an informed choice about, is mediation possible and can it play a role and a cost-effective role in your dispute resolution or dispute management portfolio. So without further ado, let's talk about the spectrum of dispute resolution tools. When we talked about litigation and arbitration, what they really do, for lack of a better term, you're outsourcing your decision on that dispute to a third party, and you are saying, I relinquish my control. So you are engaging a third party neutral. You are outsourcing the decision right to that third party neutral, and you're agreeing to be bound by that decision. Now, if we move to the left from arbitration and litigation, and if we look at the possible alternatives, we can engage a third party neutral, but to play a different role. We can look at the possibility of dispute adjudication boards, and each of these I will speak to in detail in turn, but it's nice to kind of get a pictorial of the spectrum of possibilities and then look at them in detail as we go on. So if we look at when we're moving to the left, the parties to the dispute are gaining control in that type of option selection. So if they engage in partnership or they engage in prevention, they are absolutely in control. Negotiation, they're absolutely in control. They start moving to mediation, they're partly in control. They're losing control of a bit of the structure of the process, but they still maintain control of the outcome. When we go to dispute adjudication boards, they're relinquishing their control of decision. And then again, we get to arbitration and litigation. So it's important to keep in mind what you want and what it is that you're trying to achieve, and how much control of the outcome do you want in that decision-making process. So if we take a look at the situation of negotiations, it is a method of alternative dispute resolution. It is parties' ownership. They engage in dialogue to define the contours of their dispute and to engage in identifying a possible solution. And when we see it in construction, this tends to take place we escalate through our management chain. We take it maybe away from the site, or and engage the management of the various companies to participate in this negotiation. Now, negotiation is a very positive tool because it maintains absolute confidentiality. There's no third party involved where the material can be released, or there's no risk of lack of confidentiality. The problem with mediation is it is fully dependent on the preparation, the upfront preparation, and the readiness of the parties to engage in that negotiation. And if they are not ready and the process deteriorates, there is no outside entity to pull it back if there's one party bargaining in bad faith. So yes, it can be a very effective tool. It has its place, but it has its limitations. Now, when we moved to the right of the spectrum after negotiation, what we found is the idea of engaging a third party neutral to help us with the resolution of the dispute. But what differentiates these tools is what we're asking the third party neutral to do for us. And so what is the role of the third party neutral in the various types of dispute resolution mechanisms that are available? So if we look at mediation, what differentiates mediation from the rest of these the dispute resolution tools that follow is the fact that mediation is a facilitation process. It's facilitated negotiations. The role of the third party neutral, the mediator, is purely to facilitate, not to make a decision for the parties. Now, if we start moving in that spectrum and we see early neutral evaluation, the role of the early neutral evaluator, or the third party neutral, is to make an evaluation. So they're presented with the positions of the parties and they provide a neutral evaluation which can then be used. But they do not facilitate, they just provide their evaluation of the situation as it is. If we move on from to expert determination, what we're asking that third party neutral, the expert, to do for us, to make a decision on our behalf. Not to give a recommendation, not to facilitate, but rather to make a decision. The contours or the result of the decision, if it's binding or not, we can agree to this in contract and we agree to that. But we're asking them to make a decision. If we move on again to arbitration, it's an adjudicative process. We're asking for a decision that is can be binding and final, and within arbitration, it's enforceable at law. Now, if we'll talk about dispute boards, and dispute boards are a hybrid because it can be a recommendation and it can be adjudicative, where you're asking for a decision depending on the type of dispute board, which we will talk about in turn. But the idea is dispute resolution, the techniques can be distinct, and the idea from the dispute boards is that you can start combining them. But in doing that, it's important that you have a solid foundation of information such that they can be combined effectively and the final result doesn't surprise you in terms of enforcement or time or cost or procedure. So with that, we move on to mediation and talk a little bit about mediation. I'm just going to introduce it, and Ahmed, so I won't spend too much time on this, but the idea of mediation, again, it's purely assisted negotiations. It is assisted negotiations in focusing on, rather than interests of my position is to pay I demand 10 and the other position is their willingness is to pay 5. The focus is on interests. So more of why is it that I believe that I have the right to 10, and are there other solutions that could meet my needs of why? And I won't give any more examples of interest rather than positions, because I think that will be touched upon in more detail and probably much more eloquently by Ahmed. So now, it is not an uncontrolled process. It is mediation. The mediator does control the process to a certain extent. It's controlled by rules. So we talked about the Cairo Regional Center of International Arbitration rules, CRSICA's rules that were updated in 2013. But the outcome is managed by the parties. So no, it is the parties' agreement. So he or she may facilitate how they negotiate, but the control of the agreement remains fully with the parties. Now, so the mediator, his task is just to explore interests with the to expand the possibilities. Mediators are trained in negotiation techniques, to ask questions in a certain way, to reframe, to meet with the parties jointly and individually to help identify interests and to help create possible solutions from a facilitated negotiations point of view. The mediator, the limit of the authority of the mediator only deals with the process. So while the mediator may request that certain people be included or excluded in the mediation, that is purely where the mediator's authority stops. The continuance into what is a positive agreement and what's a possible agreement still remains with the parties. Now, in that being said, some of the things that should, in general, that need to go into the selection of the mediator, because he or she is controlling the process, you want to think about the type of training or accreditation that mediator may have. You also want to think about the experience the mediator has, either in mediation, of course, but maybe within the construction context. You may want somebody who's been on site, who's been a contract administrator, who understands how to interpret the provisions of the contract within the context of the law. And moreover, you may want a mediator that understands the culture, both from an industry perspective and from a national perspective. So the cost and the availability of the mediator also need to factor in, because if we're talking about a cost-effective dispute resolution method, if the mediator is charging too much or is not available until next year to participate in the mediation, then it may not be the value of mediation in terms of cost effectivity would be lost. So these factors, it's not a one facet aspect, and these among many other aspects need to be taken into consideration when you're selecting your mediator. So again, in summary, the advantages are just that it's facilitated negotiations. The parties maintain control of the outcome. There's no agreement until the parties find it to be a beneficial agreement to them. The main aspect is, if we compare this to negotiation, having a facilitated negotiation, just when the negotiation is about to break down and everybody's about to storm out of the room, the mediator has the training and the techniques to ask the right questions, control the process in such a way that helps the parties maybe come back to the negotiation table and find a settlement. And we talked about confidentiality in negotiations. Well, mediation does provide for a level of confidentiality that whatever you discuss with the mediator in the individual caucuses, the mediator is obligated not to reveal that to the other party without your permission. So you still control, as a party, you still control your information and are able to maintain confidentiality within the process. And there's nothing revealed. So when we compare this to arbitration, we'll look at confidentiality from that perspective. Now, we can't talk about advantages without talking about disadvantages, and of course the disadvantages are mediation's only as good as the input. If the parties want to make it fail, it will fail. So there's a lot of procedural posturing in arbitration, but there are remedies and coercive powers of the arbitrator to proceed with the arbitration. Mediation doesn't have that. So it can only be as beneficial as the parties, so that is one limitation. Allow it to be. Now, early neutral evaluation, again, is a situation where we talked about where we're asking the third party neutral to give us their opinion on where the likely outcome should be. If it's a pricing of a variation or a delay estimation, then we can present our positions and ask for an evaluation. And that can help in the sense of giving a reality check to the parties as a point of beginning negotiations once again. So it can be a valuable tool if the parties have an interpretation of a particular provision in the contract. They can get an early neutral evaluation on what a third party neutral would interpret the clause to mean. They can use that and to facilitate their own negotiations without involving anybody else. Now, from moving on that, we found expert determination. We may want a third party neutral to make a decision for us, to say, is the technical performance correct, or is the quality to the standard in compliance with the contract? So we can ask a very narrow question, agree with the other party on the terms, the type of testing that would be undertaken, and we agree that the expert will, the expert report will look in a certain way, and he'll answer, or she will answer a certain question. Expert determination works very well in a very narrow question context. If we have a point of law interpretation, we can get a legal expert determination. If we have a evaluation, we can get a evaluation from an expert to determine that valuation. Where expert determination doesn't work well is if the parties themselves cannot define specifically, narrowly, what question they want answered, or what the approach should, the mechanism, if it's an accounting question, what accounting standards should be applied. If the parties can't agree to that, expert determination just won't work, because if they can't agree to the input, invariably they won't agree to the output. But so again, narrow scope of either technical cost or law. Now, expert determination works well, but it's focused on rights and wrongs. It's focused on a very narrow decision on obligations, given a pre-described question. Mediation, if we could juxtapose that to expert determination, we're asking our third party neutral to help us find a solution that's not focused on right and wrong, but help us talk through and maybe think in a new way, not use the same thinking that caused the problem, but rather have a new approach to the problem solving to find a solution and a way forward. So where expert determination focuses on the past and determining the answer to the question, mediation can focus a bit on the future and looking for possible solutions to that. Now, if we go to arbitration, arbitration is often called boutique litigation. It is private litigation. It is a very adversarial process. A few of you had indicated that you've participated in arbitrations either as claimant or respondent or as counsel, but it is adversarial. You have advocacy to prove that your position is right and you deserve damages to be compensated and made whole from what has taken place, either a breach of contract or the like. So it's governed by procedures. Initially, the parties have some sort of control. They get to choose the seat, they get to choose the procedure, they get to choose the arbitrator. But as the request for arbitration is filed, as the tribunal is appointed, and as the case file is transferred to the tribunal, that control transfers to the tribunal, and it becomes a very adversarial process. So, and the end result, of course, is that it's enforceable, and that's oftentimes why we choose arbitration as a method. So there's a winner and a loser. the decision is based on rights and obligations. The remedies are generally found to be in money, so a damages claim. By definition, it has to be more formal because there has to be an element of due process. You are advocating your position. You've selected the tribunal. They're listening and they're judging on right and wrong. So that the procedures, when we talk about the selection of the procedures, yes, the parties are free to agree. If we look at the Cairo Regional Center arbitration procedures, or ICC or LCIA, we'll find that yes, the parties can agree, but after the arbitration has started, if the parties fail to agree, and remember it's adversarial, and generally they're not cooperating, but if they fail to agree, it is the arbitrators, it is the tribunal within the context of the law and under the umbrella, if the rules are silent under the umbrella of the rules, it is the arbitrators that get to make the decision on the procedure. So you have relinquished, you've outsourced the decision, and you've relinquished some of your power. It could be a right path, but that is what's happening after in that process. Now, if we compare that to mediation, what do we find? Yes, they both start with freedom of choice. You select the process. You have the ability to select your third party neutral. But what mediation allows is that you always stay in control throughout the process. Arbitration, that control starts shifting to the arbitrators at various points and to various degrees. Arbitration, again, you're trying to determine right and wrong, whereas mediation allows you to look to the future and focus on possibilities that can meet your interests that may have not be, when you're focused on the solutions that may meet your interest, they may not be solidly focused on right and wrong. The flexibility of the process, by definition, when in an adversarial procedure, the process must be rigid, must be measurable, must be controlled. Timing as well. Everybody has to have a full or a fair, depending on the rules that you're dealing with, to present their case. So the timing can be expanded depending on the statement to claim, the statement to defense, the number of rounds of pleadings. Whereas mediation, you're not trying to prove right and wrong, so it isn't a full opportunity of presenting your case, it's approach to reaching settlement. And if we look at privacy or confidentiality, yes, arbitration, it is confidential to the extent that without the party's permission, nobody can attend the hearings. But what happens with arbitration, I think we had one person in the room when Fatma asked about the experience with arbitration. There was an arbitral award, but then there was an application for set-aside. Applications for set-aside happen in public court. So all the confidentiality may go out the window within the court procedures for application for set-aside. So there are limits to confidentiality in arbitration. And so now we talked about a hybrid approach as well, combining various contexts of dispute resolution and in the form of dispute boards. Primarily, there are two types of dispute boards: dispute review boards and dispute adjudication boards. And those dispute boards are differentiated by the output of the board. For a dispute review board, they make a recommendation. A dispute adjudication board makes a decision. So when we look at the dispute review board, they provide a recommendation that if the parties do not agree with it, if they give a notice of dissatisfaction, they're not bound by it. So unless the parties agree with the recommendation, they don't have to comply. Then they can go to the next step of dispute resolution. Whereas in a dispute adjudication board, the key difference between them is the dispute adjudication board renders a decision, and that decision must be complied with at the moment it's issued. The party may be dissatisfied and may issue a notice of dissatisfaction, depending on the contractual clause. But if there is a notice of dissatisfaction issued, they issue it after compliance, and then they go to the next step, which may reverse or not the dispute board's decision. And we'll get more into this when we touch upon the FIDIC clause, just to explain. But the key difference between these types of dispute boards, one, you're asking for a recommendation where you're not bound to comply with it. Dispute adjudication board, you're asking that third party to make a decision with which you will comply the moment it's issued. You have the right of appeal, but after compliance. So that's the main difference between the two. And why dispute boards have become popular in construction, maybe not so much in Egypt. What I understand from our stakeholders meetings is everybody crosses out the dispute boards clause 20.4 just kind of goes away. But the real advantage that's been realized with dispute boards is that there is in a standing dispute board, the parties have the dispute board members over time become cognizant of the project. So you end up with, if you select the dispute board members that have the qualifications or the background experience that is aligned with your project needs, you end up with people that know your realities and therefore can make real-time job site decisions to get on with it. So, or recommendations to get on with it. So you can have effective, fully reasoned decisions within a fairly limited period of time. And what the other collateral benefit that's been realized from dispute boards is if you have dispute board members that have worked on similar projects and have seen the execution, they have the wherewithal to kind of focus the parties' attention during the site visits and during the reading of the management report or the program management reports on potential areas of concern and be able to raise flags such that you can focus on dispute avoidance. And as we, many of us have participated in the construction industry, that the most cost-effective way to resolve a dispute is early. So it's better to prevent a dispute than it is to resolve one. And it's better to identify a problem early on and address it than kick the can down the road and hope that it goes away until you retire. Because you get layers of technical complexity intertwined with layers of legal complexity and contract complexity that it's very difficult to unravel at that point. It just becomes much, much more expensive as you go along. So if we talk about mediation and dispute boards, again, where mediation allows you, yes, you can approach a dispute board for an opinion, but that's more like early neutral evaluation, where you present your positions jointly, you approach the dispute board jointly, present positions, the respective positions, and the dispute board gives their opinion. They don't facilitate negotiations, they don't walk the parties through the possible solutions. It is based, their opinion based on right and wrong. And so it does have that limit. And so if we talk about mediation, the parties' control allows the mediation process to stop at any moment. If we've selected the wrong mediator and find that it's not going anywhere, we want to stop, the parties are free to do that at any moment. Not so with dispute adjudication boards. In my experience, it's actually easier to question an arbitrator than it is, because if it's an administrative arbitration or an institutional arbitration, because you have the recourse to the institution. But with the dispute adjudication board, you have an individual contract, a tripatriate contract with the DAB member. And unless both parties agree to release the DAB member of his duties, then it's very, very difficult to proceed from that perspective. So those are just some highlights. And with that, I think that's just the overview of the spectrum of dispute resolution tools. And what we're going to do in accordance with the schedule is we'll break for a coffee so that you don't have to hear my voice consistently, because I'm going to speak again in 15 minutes. So I'll give you a chance to relax and have some coffee so you can stay awake. So thank you very much for your attention. And if we can just be back in 15 minutes, we'd appreciate it very much.